I'm Michael Cromlin. It's my great pleasure to chair this session on public contracts. We have two speakers, each of whom will present their papers for 20 minutes, and then we'll have 20 minutes for questions. Following the normal pattern, there'll be microphones, which I'd like you to use for providing your questions so that the recorded proceedings are complete. I'll introduce the speakers very briefly because of time constraints. Our first speaker is Anne Davies, who's Professor of Public Law and Public Policy at Oxford University and also Dean of the Faculty of Law at Oxford University. Anne has been a player in this field for quite a long time now and is known especially for her 2008 book, The Public Law of Government Contracts. Her paper is The Contracting State and the Public-Private Divide. We were just noting what a wonderful job Ken Hayne did in the opening last night in preparing the ground for Anne. And indeed, both speakers, Lord Mance and Ken Hayne, last night really did launch this very topic in a most stimulating way. So I'm looking forward to hearing what Anne has to add to and by way of respond to Ken Hayne's address last night. Anne.
Thank you very much, Michael, for that introduction. So it goes without saying that governments have always used private contractors to supply the goods and services they need to perform their functions. But over the latter part of the 20th century, in the UK in particular, there's been a marked quantitative and qualitative increase in this kind of activity. So quantitatively, an increase in the amount of public money that is spent through this route, and qualitatively, a broader range of activities being regarded as appropriate for provision through contract, and deeper and more complex and more long-term relationships with contractors through things like the Private Finance Initiative and public-private partnerships. So the major focus of many public lawyers in analysing this phenomenon has been to think about whether private contractors performing tasks on behalf of the government are amenable to judicial review, or more recently in the UK to review under the Human Rights Act. This is a sort of public-private divide question. It is one that is very important to answer. In theory, at least, judicial review and HRA review would offer important safeguards to citizens and to service users. However, I think this is only one component of a comprehensive legal regime for outsourced public services. There are at least two other important elements required. One is to establish the extent to which the government itself is subject to judicial review or HRA review in respect of its activities as a contracting party. And the other is to determine whether the doctrines of judicial review themselves are fit for purpose in order to ensure that the government and its contractors are accountable for the proper use of public funds and the delivery of public services. So as Michael's just pointed out, it's about 10 years now since I wrote a book on this issue. So in the paper, I've really taken the opportunity to see what's been going on since then. And so my focus is on recent developments, and there have been some, but not a great deal has changed. The problems I identified then haven't gone away. A couple of new problems have come along to join them. Normally at this point in the paper, I would then spend some time explaining and justifying why you should be interested in this topic at all. But Ken Haynes done that for me, so thank you for that. But let me just give you one little vignette from recent UK experience just to explain why this is so important. The UK's second largest construction company collapsed in January of this year. It's a company called Maclean. It employed 20,000 people in the UK. It had 450 public sector contracts. 38% of its revenue in 2016 was from the UK public sector. A lot of its business has been picked up by other contractors, but the situation has caused considerable uncertainty and disruption for its workforce, its suppliers, and for the public sector. Of course, it would be completely wrong to suggest that Maclean's collapse is in some way a failure of public law, and there's all sorts of parliamentary inquiries and so on ongoing. But what it highlights for me is what a big deal this is and how strange it is that it remains often at the margins of our concerns. So let me start with the judicial review of contractors question. I've got various background bits in the written paper which I won't address now. So the sort of classic question is, should the contractor be regulated by public law when it's carrying out tasks on behalf of the government under the contract? Of course, that assumes that it matters, that public and private law often offer different forms of regulation. I'm not going to try and tackle that question in the next 15 minutes. But in English law, the way this question has been addressed, the way it's been formulated in court, has been whether the contractor is performing a public function. That has been the test in the Human Rights Act, and the judicial review approach is very similar. So in judicial review, the two leading cases, Servite and Partnerships in Care, require the claimant to show something more than just the presence of a contract with a public body in order to bring the contractor's activities within the scope of judicial review. This is often expressed in the phrase statutory underpinning. So if you're just, Servite's provision of accommodation, residential accommodation for the elderly. That was just the provision of accommodation under contract to a public authority. There were no special powers or duties attaching to the provider, so that was considered not to be amenable to judicial review. The contrasting case, Partnerships in Care, the firm was providing a hospital. It had special duties under statute to provide appropriate care of various kinds, and so the court found that there was sufficient statutory underpinning there to make the contractor subject to judicial review. And in fact, the Human Rights Act case law is very similar, even though judges often express differing views as to its precedential value and the extent to which you can cross-refer. So in Poplar Housing, the claimant was challenging her eviction from social housing by a housing association which was under contract to a public authority. The court finds there sufficient public element to bring this under the scope of the Human Rights Act because the private firm was deciding her entitlements in the sense that it was evicting her from her accommodation. The contrasting case is YL, which is very similar to Servite that I referred to earlier. It's provision of residential care to the elderly. And just because that's just the provision of care, there's no kind of special statutory duties or determination of entitlements attaching, it's found not to be subject to the Human Rights Act. The problem with both of these lines of case law is that this test of statutory underpinning makes it look as if we're doing something terribly scientific here, when fundamentally what we're doing is making a policy choice about how this activity should be regulated. So that has the unfortunate effect of obscuring the reasons underpinning the policy choice, and then we have to do a bit of detective work to figure out what those are. And a big part of the court's concern in this area has been about burdening contractors with those very challenging public law obligations, even though, of course, if contractors knew that they were going to be subject to these obligations, they would be able to factor them into their planning, to their contract pricing, and so on. I think there are more helpful ways of thinking about that set of issues, but that's not my primary focus today. So what I really wanted to say was that this focus, which is undoubtedly important, does also have the slightly unfortunate tendency of obscuring the two other sides of the government contracting triangle, as it were. So the citizen's relationship with the government and the government's relationship with the contractor. And a really comprehensive regime for government contracts would be addressing those issues too. Now, in the written paper, I examine each of those relationships separately. I'm going to present the material slightly differently now, just because I think it's more efficient given limited time. So I'm going to just address two questions. What are the prospects of getting judicial review of the government's own decision-making in the contracting context? And the second question, should we be thinking primarily in terms of keeping the government under control in this context anyway, which I think is quite a big question. So let's start with the judicial review question. Stick to familiar territory, and I'll do the risky stuff at the end. So the availability of judicial review of the government in the contracting context is another type of public-private divide sort of question. Is the government subject to public law norms when it's engaged in placing and managing contracts, or whether it has a private life in which these activities are regulated only by private law? And curiously, what it turns out, at least in terms of the recent English case law, is that there are some opportunities for judicial review of government decisions in this setting, but claims are much more likely to succeed if they're brought by contractors and not by citizens or other interested parties. And that brings an element of the private back, in the sense that government contracts are being seen, even in a public law setting, as fundamentally the business of the parties rather than the business of the wider public. However, I should add a caveat here, which is that this is quite a small body of case law, and we should be careful about reading too much into it. So, in terms of judicial review applications brought by contractors, the courts are quite clear about the fact that you can't dress up a straightforward contract claim as raising public law issues. Quite rightly, there are special remedies under the procurement regime for disappointed bidders, but there is a sort of emerging area in which judicial review is also available. So a nice, neat example of this is the Trafford case. The applicant in this case is a solicitor. She rents an office from the local council. She then acts for a number of claimants who bring claims because they've tripped on the council's highways. And the council decides that it is not in its best interest to have this wicked solicitor renting an office from it. And so when her lease comes to an end, it decides not to renew the lease. This decision was found to be amenable to judicial review on the basis that the authority was acting for an improper purpose. And I think it's a really interesting case in terms of this point about the government having a private life when it's engaged in commercial activities. A private landlord could decide not to renew a business lease for their own capricious reasons. But there's a real reluctance to say that a public authority should enjoy the same freedom, even though the solicitor had no right to the renewal of the lease and could readily have found other premises. There's another interesting group of cases, again, around residential care, which is a big area for litigation. And this is whether the potential contractors can challenge the rate that the local authority is willing to pay for a resident in a care home per week. This issue first came up in a case called Bevan and Clark, and it was found that the council's decision was amenable to judicial review because the council does not have the freedom that a private individual would have to bargain the price down to the lowest possible level. And that was because of some government guidance that suggests that local authorities should consult with local providers when they're setting the rate and should take into account their long-term sustainability. And of course, again, the contractual analysis of the situation would be different. If A sets an upper limit on the price they're willing to pay for a service, B can decide whether or not they want to enter into a contract at that price. Of course, in the case of care homes, it's rather more difficult to exit the market because of obligations to make alternative arrangements for the people receiving the care. But there's a very different picture when we look at judicial review claims brought by citizens in the context of the government's contracting decisions. And I'm going to have to skate over this a little bit for reasons of time. But it's very difficult to get standing in this area, even though English law is very open to public interest claims of one sort or another. The courts have sort of recognised that this might be a possibility and then almost immediately closed it down. And there's a very recent case in which it was suggested that the only actor who might be able to bring judicial review, who was not themselves a contractor, would be a contractor's supplier, not an interest group or a concerned citizen. Again, it's a small group of cases, so we do need to be a bit cautious about it. The other problem is timing. When do you bring the claim? There's a set of cases about the London Borough of Barnet, which decided to contract out pretty much everything that it does into two massive contracts. There's a long series of decisions in the council over a period of some 2 years. A trade union, very concerned about this, eventually brings an application for judicial review and then is found to be out of time because it's waited too long for that policy to crystallise before challenging it. It's very difficult, even with hindsight, to determine when would have been the right point to challenge that policy development. So we haven't even got on to the big question that Kenneth Hayne raised last night, which was judicial review of the government's sort of contract design and management of contract decisions and what sort of doctrinal developments we would need to accommodate judicial review or to develop judicial review, adapt it for that area. So this is an area, I think, which is ripe for more litigation, but the courts need to be open to a range of different challenges. So in my last 5 minutes, let me proceed to my other and somewhat more controversial point, which is if we are going to get, as public lawyers, more involved in this area, I think we need to test our assumptions. So our assumption often is that the government is the most powerful party in the relationship and needs to be kept under control. The contracting context challenges that because it's very easy for governments to contract away a lot of their power in ways which then mean that either we need to stop them doing that or we need to give them some help when they find that they've done it. So it builds in several steps, and you might need to look at the written version to see the detail. But it starts with a sort of structural point. We talk about, I talk all the time about government. Government in the contracting context doesn't function as a big monolithic thing. And in the UK public sector in particular, it's been broken down into very many small autonomous units. You look at healthcare, you look at education, we're talking about lots of little bodies that are able to place contracts. The market, on the other hand, has become considerably more monolithic over time, and that was kind of my point in mentioning Carillion. When outsourcing first kind of came into fashion, it was suggested that what would happen would be that the government would be able to contract out to specialist contractors who would develop expertise in particular areas of activity. That's not what's happened. They contract out to a very small number of firms for whom being a government contractor is in itself a specialism. Carillion had contracts across the full range. It was building hospitals, maintaining highways, providing accommodation for service personnel, cooking school dinners, all kinds of different things. So that then creates quite a big problem for the government. So although in theory the government should have very considerable bargaining power to get good deals, it's organised itself in a way in which it's losing those advantages. And it can expose itself to unexpectedly high levels of risk by having placed multiple contracts, which it doesn't even know it's done, with a single entity. Now, I don't want to suggest that the contracting process should drive the way that the government organises itself or that the government is responsible for the shape of the market, but we do need to think quite carefully about whether keeping the government under control is the sole objective here. And in the written paper, I fleshed this out a little bit by giving an example around the procurement process, which is all about controlling the government, stopping it from making whimsical decisions, forcing it to accept the lowest or best value bid after a competitive process, but making it very difficult then to determine whether that bid is abnormally low, whether it is a bid that the contractor is not actually going to be able to deliver at all because it's priced at so low to win the contract that it's unsustainable over the longer term. So it's a nice example of where being really strict about keeping the government under control, reducing its discretion, is actually potentially quite harmful in this difficult context. So just to wrap up then, there are, of course, lots of reasons why this area of law doesn't get much attention. Perhaps it doesn't matter. Perhaps contracting out will go out of fashion in the same way that it came back in. But I think it's unlikely, really, that governments will stop using contracts. So if we think that public law makes a contribution to legality, rationality, procedural fairness, human rights compliance, when the government acts alone, it seems to me that there's no reason why it shouldn't also do so when the government is acting with a contractor. So we need creative thinking, we need strategic litigation, and we need really thoughtful lobbying in this area. Thank you.
Thank you, Anne. I was particularly taken by one point you made in relation to your risky topic, the attempt or the need, really, for disaggregation of a monolithic concept of government. That's something not unfamiliar in this country, although it's the Crown that we're trying to disaggregate rather than any concept of government. Our second speaker is Professor Janet McLean, who's a Professor of Law at Auckland University, where she's also been Associate Dean Research. Like Anne, Janet too has worked in this field for a long time and has published widely on matters such as the public-private law divide, the nature of the Crown, to pick up that last point, bureaucratic design, and specifically public contracting. Her paper, I'll give you the short title, is for, I emphasise the first word, for a law of public contract per se. Janet.
Thank you very much. I realise I'm the only thing between you and lunch, so I will be bold today if I can. My argument is that we ought to view all government contracts as presumptively public, as a special category of contract subject to its own specially tailored rules. I don't develop in my paper what those rules should be, but I want to leave open the possibility that those rules could potentially be derived from both public and private law. The argument starts by framing the problems presented by public contracts and how existing public law doctrinal attempts to deal with them fall short in various ways. I then turn to liberal contract theory and its underpinnings to identify the public element in all contracts, and then consider how these prove to be problematic for public contracts and require adjustment. So my aim is, rather like Justice Haynes last night, to open a conceptual space for the development of a distinct law of public contracts. Rather than attempting to vaunt the barrier the existence of a contract has traditionally posed for the operation of public law values, I seek to prize apart liberal contract theory from within in order to identify spaces in which public law norms should be able to operate. There are, as we've heard from Anne, numerous reasons why government contracts should be viewed as central to public law's concerns. And like her, I want to argue that these go well beyond the usual focus on integrity and the potential for government abuse of power. Governments need to maintain their ability to govern in perpetuity. More fundamentally, the idea that governments are able to enjoy different legal powers and moral capacities depending on whether they're acting as a public authority decision maker or as contractual entities suggests that the state can choose the legal instruments which define its moral capacities and its relationship to its citizens. And if that is so, there can be no fixed relationship between the citizen and state. The common law's traditional focus has been on the public entity's capacity to enter into the contract. Ultra vires tests have sought to determine the purposes for which contracts can be entered, and no fettering rules, so far as they go, have sought to protect a government's capacity to govern. But given the increasing reliance of governments on contract to supply core public services, I just think it very unlikely that courts are going to be able to invalidate contracts by way of capacity tests such as these. And that's especially so when this leaves the private party with no contractual rights at all and does nothing to ensure the continuity of services to the public at large. More than that, capacity tests confine public law norms to the determination of whether the contract is valid, but once that validity is established, public law norms cease to play a role. And this effectively corrals public and private law into separate spheres. The public law decides whether it's a valid contract. Once it's valid, it has nothing more to say. I leave the Australian constitutional story, Williams, to one side here, mercifully. Of course, more recently, as Anne's told us, courts in the UK and New Zealand and elsewhere have entertained the possible application of judicial review norms inside the contract itself, although these also sometimes go to validity. But in doing so, they have created formidable presumptive barriers against the imposition of judicial review norms in the contractual space. They've erected a superadded public element requirement and have restricted the grounds of judicial review. Anne has written elsewhere that this has the effect of marginalising the idea of public contracts, and in any event, I wholeheartedly agree with her that the existing grounds of judicial review are not always a good fit in the contracting space. So I'm going to take a different tack. My argument is that all government contracts should be treated as presumptively public, regardless of their subject matter, regardless of the function that's involved, and without the requirement of any superadded public element. And the way I want to argue that is to base my argument on the logic of liberal contract theory itself. Yes, you heard right, and probably I want to base it on liberal contract theory itself, the fundamental commitments of which, I argue, cannot apply to government contracts, at least not without difficulty or adjustment. So when I've given this paper before and I've said I'm going to look at liberal contract theory, the public lawyers recoil in horror. I saw Justice Palmer do that just then. Some of the private lawyers do too. I didn't see your face, Steve. But they say this is improbable. I start with it because it is the plausible theory, and I don't think libertarianism is a plausible theory. It's the plausible theory which is apparently the most hostile to public law values, and because it presents the greatest ideological barrier to developing a law of public contract as a distinct concept. So turning to that now, before lunch, briefly, liberal contract theory acknowledges certain minimal public elements which apply to all contracts, and the liberal theorists don't differentiate between contracts between individuals or contracts between individuals and the state. First of all, they acknowledge the public political role of contract law as enabling and protecting human freedom and the ability of individuals to pursue their own version of the good consistently with the freedoms of others. Contract law then represents a realm of freedom into which the collective pursuit of the good life ought not to be able to intrude, and about which the state should be neutral. The constitutional political value of human freedom then is at the core of liberal contract theory. Secondly, most liberal theorists recognise that the state plays an essential role in the enforcement of contracts. At the very minimum, liberal contract theorists need to have a story about the public institutions which enforce contracts and limit what enforceable contracts can be about. So public institutions must be large enough and again neutral enough to perform these functions and to sustain themselves in perpetuity. And finally, while there's controversy among liberal theorists about whether contract law serves a role in distributive justice as well as corrective justice, all liberal theorists acknowledge the distributive role of the state. My argument is that these three minimum public elements take on a new cast when one of the parties to the contract is a government entity. To put it briefly, liberal freedom is challenged when it is the state pursuing the collective version of the good through contract. Liberal neutrality is challenged when it's the state entering into special arrangements with selected others. And the corrective justice role of contracts is compromised when it's the state which is one of the contractual parties. So let me just sketch those arguments a little bit more. So to start with the constitutional political freedom enhancing role of contracts. One of the reasons why contractual choices are considered to be entitled to legal respect is because they give effect to subjective rather than objective versions of the good within a zone of freedom. Within the parameters of the contractual zone of freedom, different versions of the good actualised by contractual agreement will be neutrally supported by public legal entities. This doesn't just enhance human freedom of individuals, but it also has benefits beyond the parties in fracturing and multiplying human authority. So, as Dagan would argue, contracts are not just good for individuals serving autonomy, they also serve pluralism. Well, this liberal justification for respecting contracts cannot apply without adjustment when one of the parties is the government. Government cannot be said to enjoy autonomy or privacy, and the state's role is to secure the interests of its citizens and not to pursue private preferences. Indeed, if an official in one of these small disaggregated parts of the state were pursuing an individual private preference, there'd be something wrong with the contract for another reason. So government contracts necessarily purport to give effect to the collective pursuit of the good life, to reflect public collective values rather than as representing a form of resistance to or independence from them. Now, of course, that's not to say that the private party which has joined its preferences with government for a certain limited project by contract is not voluntarily pursuing its choices and for its own reasons. But such choices may be entitled to respect not for the standard liberal reason that they represent a sphere of individual freedom wholly independent of the collective. There may, of course, be other reasons to respect such commitments, and I think Dr. Stark's going to talk about this afternoon, such as the importance of government promise-keeping and the protection of reliance interests. So it's not only the case that government contracts do not foster pluralism, but they can actively damage it. For example, contracts for social services delivery commonly contain confidentiality and other clauses which seek to rob the private party of their advocacy function about the extent and nature of social needs and the adequacy of public programs. A constitutional freedom of speech calculus ought to apply to such clauses, rendering them, in some cases, unenforceable, and even if that's contrary to express contractual terms. I think that's an instance where a distinct law of public contract would better serve the liberal project than classic contract law rules. We've got some examples from the 80s, I think, where public law was used to stop abuses of power of this kind of ideological kind. They didn't depend on any superadded public element. Well, that's the easiest argument for those of you who are still with me. The other arguments are more difficult because those arguments that I've just rehearsed go to the classic government abuse of power in a contract, the classic liberal questions. But the more difficult arguments are those which go to try to preserve government capacity, government power, and the effect of government contracts on liberal neutrality. And in this part of the argument, draw breath please, I draw in aid of Ripstein's liberal theory of contract based on Kantian views of the state. Sorry to do this before lunch. My argument is that government contracts are presumptively at odds with the government neutrality, which is the basis of the government's right and ability to govern, including its power to enforce contracts. So as we've heard today and last night, government contracts are only ostensibly in the pursuit of the collective will. It's always a bit of a fiction to credit contractual terms as representing the collective good, even when there are no stark integrity issues obviously in play. Contracts are made in secret. One part of the government apparatus is often able to bind the whole, and worse than all this, governments commonly contract out the contracting process itself to private actors. The phenomenon of governments contracting with special others and the reciprocal duties such contracts create between the parties imperils state neutrality, equality under the law, and the state's broader duties in a way that goes well beyond existing rules. Recall that alongside the liberty-fostering function of contracts, liberal contract theory recognises that the state must be large enough and neutral enough to maintain its role as the enforcer of contracts in perpetuity. What distinguishes the state's enforcement of contracts from coercion between individuals, according to Ripstein, is that the use of coercive power issues from a public standpoint we all share. The state's enforcement powers are conditioned on the existence and exercise of the united general will. And there are demanding conditions under which such a will can be formed. For example, the state is required to eliminate relationships of dependence and to secure the equal freedom of individuals in order for the conditions to exist for the creation of the united general will within a Kantian framework. All government contracts, I argue, have the potential to interfere with the state's ability to secure the equal freedom of individuals. By definition, a contract brings the parties closer to each other than to other members of the same political community. And this is a correlative relationship which entitles one or both of them to act in ways they were not previously entitled to act and to change their respective rights and duties in relation to each other. Contract is a mechanism by which parties create law to operate between themselves. Thus, where government is one of the parties, there are implications for the maintenance of equality under the law. And that remains the case however fair the tendering processes and entering that contract may have been. Now, these implications for equality under the law, I think, are most obvious and acute in contemporary times in those public-private partnerships which confer concessionary privileges on private parties. And I've used the example of New Zealand's granting exemptions to the gambling laws in exchange for the building and management of a convention centre as a striking example. But such examples only reveal more starkly the tensions between contractual reciprocity and the maintenance of citizen equality, which are potentially present in all contracts. For the duty to secure individuals' equal freedom belongs to the state alone, and all government contracts potentially compromise it, or at least presumptively potentially compromise it. The state's duties to people other than the immediate contractual party are an important factor that liberal contract lawyers ought to be concerned about within their own framework, notwithstanding their privity rules, and perhaps adjusting their privity rules. To ignore these is to put at risk the very basis on which state institutions are able to enforce contracts more generally. Finally and briefly, many liberal contract theorists would resist the claim that contract law performs a distributional role. In doing so, they seek also to resist the consequentialist and utilitarian analyses commonly justified by these claims. But every contract with a public entity, whether it's about roading, paper clips, or social services, is redistributive, has opportunity costs, and hence has consequences for the relationship between the state and its citizens. All three of those factors, I think, then, destabilise government contracts and render them problematic from within a liberal contractual frame. So in conclusion, viewing government contracting from within the apparently hostile framework of the liberal contract tradition, it's possible to imagine a space for the development of a distinct law of public contract. In order to do so, it's necessary to commit to a particular conception of the state and to acknowledge the state's role in private law. And it might be no accident that we had to go to the civilians to Prussia to find someone who helped us do that, but I think that we have space here in the common law to develop these ideas. Thank you.
Thank you, Janet. Now, we have time for questions, and we have microphones, which I'd ask you to use. Please state your name and any affiliation, and if you could direct your questions as succinctly as possible to each of our speakers, that will, I think, maximise the chance for a lot of participation. So, yes, we have one already.
Question for Janet. I'm Jacob Weinrib, Queen's University, Canada. So, Janet, throughout your comments, there's a certain conception of the subject's relationship to the state, one I take it in which the individual is free to determine his or her own ends, and in which the state, in contrast, has a set of obligatory ends that it can't opt out of through any act. And I'm wondering how this frames the way you see the law of public contract. So would it be the case that the state would, unlike a private party, when forming public contracts, be unable to determine, select its own end? Its own ends would actually be given by its own status as the state. And correspondingly, the role of that public status would be to actually, in every public contract it enters, secure individual freedom. And that duty on the part of the state would actually exhaust what the state could do through public contracts. So my general question is, how does this way of thinking about the relationship between ruler and ruled frame the ultimate account you want to give of what a public contract actually is? What does that normative space look like?
Wow, that's a hard one. So can I just break that down? So the first thing you were asking was, did I think states got to select their own ends? And I want to say that's political, right? That's in a political space, and it's in a contingent political space. And I think that's partly what I am trying to set a place for in public contracting, that if a contract just proved to be so bad or locked in a state in a way that was just against what the collective good could stomach, there must be ways to adjust it without that being rendered tyranny or fiat by the state, right? Our usual response and private law response to that is that's the state being tyrannous and against the rule of law. What I'm trying to say is there might be a rule of law justification from the United General Will that views that change of heart, change of purpose in a way that is much more benign and justified in a rule of law terms.
Thank you. Yes, Mark. In the front here, thanks.
Mark Aronson, University of New South Wales. Thank you both for those wonderful papers. I must say, as a non-theorist, or perhaps I'm theoretically literate, but that's about as far as I'd take it. I'm wondering where this is all going to lead. Anne points out the various problems and ended her paper by saying, I'm not sure of the solutions. Janet says, let's have an entirely separate regime of law for government contracts. Ken last night, I don't think was suggesting either of those things. I think he was suggesting rather better processes, publicness and so on, all of which of course are against the dominant ideology of how you form a contract, which is essentially private, no one else's business, doesn't have to be justified to anyone else, nor need have a good business case. Some of the government contracts are classically stupid, not a problem of lacking integrity, they're stupid. And as you say, Janet, even the process itself is outsourced to the large accounting firms. So I'm wondering, do we need to reconfigure a whole lot of public-private theory to justify legislative intervention to correct some very obvious failures? Failures of process, accountability, pricing, and so forth. Would that not be a more achievable goal?
I think that's probably directed to both.
Yeah, could I just...
Yes, it is.
So let me confess, I know there are some Supreme Court judges at the New Zealand court here. Should you have to look at the Sky City Convention Centre deal again, should there be legislation that unravels that, and then there's an argument this is a breach of the rule of law and so on, then I want there to be some resource to say, well, actually, it's more... There are public values here. So partly my intervention, I don't think when I die, I don't think there'll be a separate law of public contract, but I want there to be space for these sort of arguments that say this is different, this is justified, the rule of law is still operating here. When legislatures interfere where existing contracts were just stupid or immoral or whatever. So that's partly what my intervention is about.
Anne?
Yeah, so, sorry, I'll just move up. Sorry. Thank you for that question. Coming at this from a UK perspective, there isn't a great deal of point in thinking about this in terms of legislation, because the way our system works is that the government is very dominant in the legislative process, and so the likelihood of it proposing legislation to regulate this area of activity over which it currently enjoys substantial discretion is very remote indeed, which is why I'm a bit more focused on what the courts might do. I mean, the argument in the book really is for a mixed system in which, the basic underpinning of this is the ordinary law of contract, but then we need some additional public law doctrines and additional interventions to really address some of the concerns that I've been raising. But you're right to point out that there are some really obvious failures out there. I mean, that I could give you a large number of examples, but a nice one is the way in which the UK government relatively recently contracted out probation services. It did so on the basis of a payment by results contract, which looked at whether people were got into work. It did not set any kind of time limit on how long they had to work for before the payment would be made. And it had the obvious result that many people whose prospects of getting a job were quite remote received no attention at all from the private probation providers. Now, it seems to me that that is ripe for judicial review of the government in terms of the design of that contract. There are a variety of existing doctrines that we could call in aid in that context, but it's just not happening. So that's why I'm thinking more in terms of strategic litigation than legislation.
Yes.
This again is a question to both of you. I wonder whether there should be special attention to the tendering process. You see, in some systems, common law systems, this has been legislated. I'm quite dismayed to learn that there are very few companies that manage to retain the status as contracting with the government, and that seems a very unfair way of using government sources rather than allowing more companies and providers to enjoy that. So this, in addition, or at least as a beginning of a more structured arrangement, I totally agree with Janet on that. At least that part of the government action may need to be legislated first.
Again, just from an English law perspective, one of the major difficulties in this area is that the EU public procurement rules, which are well-intentioned and about opening up procurement markets around the EU and making sure that there isn't nationality discrimination in the way that governments award contracts, have had the unfortunate side effect of making it quite difficult for small and medium-sized enterprises to bid for government contracts because the process is quite complex. You need to know what you're doing, you need to know where to find the contracts, you need to know how to put a bid together. There are lots of efforts within EU public procurement law to address that, but I think it has been, unfortunately and accidentally, a factor in the market becoming quite concentrated among a small group of big firms.
Most of the action in my jurisdiction has been in tendering, and there are elaborate tendering processes. Our problem is we're such a small market that we won't have anyone to do something, and then, I mean, one of the big cases, one of the members of the tendering panel went out to try and encourage people to bid, right, and then were they impartial? And so we have opposite problems where actually, especially where social services tendering happens, so you want someone who will service the Pacific Island community, the government has to go out, build capacity, sort of create the body, and then have them tender for the... So they're all over every side of that process. So yes, there are really big tendering problems. But there's been more attention to that end than there has been to almost anything else in government contracting in my jurisdiction.
Thank you. I'm afraid, time being what it is, I am going to have to bring this session to a close. I do so with real regret because I think we've opened up issues of enormous significance, the distance that we've travelled from a Daviesian view of English law, and that allegedly inherited by so many of the former colonies is quite dramatic. And both our speakers, I think, have shown in different but complementary ways that in turning our backs on past assumptions, we've created a large number of questions that Ken Hayne suggested, and they have further demonstrated must be resolved in the not too far distant future. So I'd ask you to join me in thanking both of our speakers in the normal way.